Dental Law and Ethics, Lesson 3, Civil Law and the Dentist. Civil Law. This deals with situations where one person sues another for personal wrongdoing, and it's divided into contract law, specific agreements between people and violations of those agreements. A contract equals an agreement between two or more competent parties covering a specific act for consideration or a fee. Tort law, a wrong that involves a breach of a civil duty owed to someone else. A person may be held liable for another's injury caused by them. The dentist-patient contract. To be a valid contract, those entering the agreement must be legally competent, no minors or mentally incompetent individuals. The act covered by agreement must be lawful. It does not cover illegal acts. There must be a consideration involved in the contract, payment in the form of money or services, and it cannot be done for free with no payment or exchange for goods or services. Types of contracts. Implied consent. Contracts that are based on certain actions, even if a legal binding contract may not be involved or discussed here. Expressed contracts, where a written or oral spoken agreement is made and signed, such as a treatment plan or a financial plan. Legal responsibilities. The dentist's responsibilities to the patient include being properly licensed, skill, care, and judgment, patient autonomy, do not abandon the patient, refer to a specialist, standard techniques, materials, and drugs, reasonable results within a reasonable time, patient privacy, adequate instructions, and reasonable fees. The patient's responsibility to the dentist. All instructions will be followed, for example, postoperative instructions, home care instructions, treatment such as wearing elastics, controlling diet, conducting oral hygiene, etc. Appointments will be kept. Fees for services will be paid. Patient will conform to generally accepted modes of behavior. Patient will be truthful regarding their health history and other administrative inquiries. Breach of contract. The failure, without legal excuse, to perform an obligation or duty in a contract. The patient may sue the dentist if he or she feels there has been a breach of contract. To avoid this, it's important for the staff to document all events, actions, and conversations should be documented in the patient's chart. Defense against breach of contract. Dentist has fulfilled all agreed-upon requirements. The patient has not given the dentist a reasonable opportunity to satisfy where satisfaction has been promised. Patient's withdrawal from contract by failing to return. Patient's contributory neglect by failure to, patient's contributory negligence by failure to follow instructions, for example, written or oral postoperative instructions. The 4 Ds of tort law. To determine if a tort has been committed, number 1, duty. A legal duty must be owed to someone. The dentist has specific legal duties that need to be followed with their patients. Number 2, dereliction. Abandonment or failure to perform a legal duty. The dentist has failed to perform the legal duty owed to the patient. Damage. Physical or psychological injury to the patient. The dentist has caused injury to the patient. And number 4, due to proof that the dentist's actions are caused by damage to the patient. The dentist's actions must be direct cause of patient's injury. Establishing a legal duty. The doctor is not obligated to accept patient. The doctor cannot refuse a patient into his practice based on race, gender, religion, nationality, or medical or physical conditions. The doctor should not accept the patient if the doctor is not trained or equipped to provide proper care for the patient's needs. Patient of record. The dentist has accepted this person as a patient. The patient has accepted treatment recommendations, and the dentist has accepted payment for treatment. The dentist has definite responsibilities to that patient. Emergency patients. The doctor is required to see a patient of record. The doctor is not required to treat a new patient in an emergency. However, ethical obligations to see a patient in pain or to refer them to another dentist or hospital who can provide treatment. Liabilities in dentistry. Number 1, breach of contract. That's an unfulfilled agreement. Number 2, maligning a patient. Using written or spoken words to damage a patient's reputation, like slander or libel. Be careful what is written in the patient's chart. Number 3, permitting a hazard into the office. Wet floors, broken down equipment, failure to keep up with equipment needs. Number 4, technical assault. Touching or treating a patient without their consent. Always ask before touching a patient. Patient or legal guardian must give consent before any treatment can be performed. And number 5, malpractice. The dentist does not adhere to the standards of care generally accepted by the dental profession. Malpractice. Malpractice can be due to ignorance or neglect, lack of skill, or neglect in applying these skills. Malpractice has occurred if the dentist has accepted the patient and the dentist has failed in one of his or her duties to the patient, and the direct cause and effect relationship between the dentist's breach of duty and the patient's injury, and damage or harm to the patient as a result of the dentist's breach of duty. Many hidden factors influence the patient's actions and reactions. Fear is often a major reason. Financial worries, emotional responses, psychological implications. From a patient's point of view, any problem is potentially a major one.